The Court of Justice of the European Union is made up of two courts, the Court of Justice and the General Court. Since its creation, this second court of the European Union has seen its caseload evolve. To explain this evolution with us today, the President of the General Court, Mark van der Woude. President van der Woude, thank you for being with us today.
Good morning.
Has there been any evolution in the case law before the General Court?
Indeed, it started with competition cases and staff cases, and it has grown over the years. And basically in 2001, with the Treaty of Nice, we could say that the General Court covers basically all the areas in which the institutions, agencies, of bodies of the European Union are active in one way or another. So basically all direct appeals go to the General Court, with the exception of, say, clashes between the institutions. They go directly to the Court of Justice. So everything which the Union does directly on the field is something which could eventually be a subject matter for litigation before our court.
Are there some directions that the institution took?
The major step was taken recently in 2024, when the Court of Justice transferred preliminary competence to answer preliminary reference questions to the General Court in 6 specific areas. So that's one very important development, and that went together with, say, a system of prior authorization of appeals in certain areas as well.
Are there new areas in which the General Court is now involved?
It's very difficult to answer that question because it's so varied. The General Court basically deals with all subject matters in which the institutions are active. And you can have various ways to look at it. You could say, for example, if there is a crisis, the Union acts. For example, it was a banking crisis in the first decade of this century that led to regulation, and that regulation and all the decisions which are being taken within that framework may end up before our court. Now we have, to say, the digital revolution, and that leads to all sorts of regulations like the DMA, DSA, that also fuels new litigation. The environment, another issue, that's a constant crisis. We have questions on the taxonomy of cases, on carbon capture cases. It's very varied. All that together with, say, an increased possibility for applicants to go to the court under the latest revision of the Aarhus regulation. And more in general, I would say that with the increase of the regulatory activity of the European Union, the likelihood of litigation in those fields has increased considerably. And one particular example, electricity litigation, or when it comes to gas, under the many rules which the European Union has issued for the creation of a pan-European energy market.
Thank you, Mr. van der Woude, for this explanation on the evolution of the case law before the General Court.
Thank you very much.
See you in the next episode of Open Court.